A very good evening, distinguished guests, ladies and gentlemen. My name is Jaya, and on behalf of NUS Law, I'm extremely delighted to welcome all of you to the C J Koh Professorial Lecture. NUS Yes. Sorry for the technical glitch. NUS established the C J Koh Professorship in honor of the late lawyer and philanthropist Mr. Koh Jun Chu. Established in 1996, the professorship was to enable the Faculty of Law to engage distinguished legal experts who will teach and participate in research, bringing their knowledge and unique perspectives to the NUS community and to Singapore to further its ever-growing regional and international role. The professorship is supported by a generous gift from the estate of C J Koh. Professor Sornarajah has held the appointment of the C J Koh Professorship for many years now. He has established himself firmly as an expert in public international law and international investment law and published widely. Today, Professor Sorna will deliver his lecture on the past and future of the international law on foreign investment. The chairperson for today's lecture is Professor Anthony Angie from NUS Law. It is my pleasure now to invite Dean of NUS Law, Professor Simon Chesterman, for his welcome address. Professor Chesterman, please.
Thank you very much, Jaya, for, among other things, for testing the microphone for me. Distinguished guests, ladies and gentlemen, nothing gives me greater pleasure than celebrating the achievements of my colleagues. Whether it's the launch of a new book, the triumph of our former students, or evidence that research and teaching is changing the practice of law, our colleague Sornarajah stands out as one of the most recognized and celebrated professors at NUS Law, and it's a delight to be here this evening to hear his professorial lecture. He'll get a proper introduction momentarily, but I can't resist highlighting that in the past 4 years, he has produced 4 books. We're not launching a book tonight, which is remarkable. We've launched many of his books. But I raise this partly because another colleague put it to him informally, look, Sorna, you've had a great career. Why do you put in so much effort now? Sorna and I were mystified by this comment, as he explained to me. But I think, having known him for a few years now, that there were 2 factors at work that continue to drive him to produce these books and to produce papers like the one he will present tonight. The first is, despite a long and distinguished career, he's still got a lot to say. The second is that although a growing number of people concede that he's right, not all of them do. And he's persuaded to keep on going until all of them agree that he's right. Before I invite our chair to take over, I do want to acknowledge the tremendous impact of the donor in whose name Sorna's chair is endowed, the philanthropist and lawyer, Mr. Koh Jun Chu, known as Mr. C J Koh, as Jaya was just saying. I never had the privilege of meeting Mr. Koh, but his legacy at NUS Law is clear. In addition to the chair that Sorna holds today, our students study in the C J Koh Law Library just across the quadrangle, a name it has held for almost 2 decades. Mr. Koh's name also supports scholarships and other initiatives that have had a tremendous impact on legal education and research at NUS and indeed across Singapore and the region. Mr. Koh was born in Indonesia in 1901 and became a lawyer in England at a time when it was not possible to study law in Singapore, as Mr. Tan and I were just discussing. He moved here nonetheless and joined Sir Song Ong Siang's firm until he set up his own practice. Mr. Koh was a true Renaissance man, enjoying poetry and fiction, philosophy and the arts, as both a consumer and a producer in his own right. Indeed, several of his oil paintings are on display in the C J Koh Law Library today. He lived a full and rich life, passing away at the age of 96 in 1997. Yet his legacy and his vision live on. NUS is also grateful to his trustee, the late Mr. Ong Tiong Tat, for the sincerity and enthusiasm he brought to continuing that vision. And today we are privileged that Mr. H. Tan, the nephew of the late Mr. and Mrs. Ong Tiong Tat, has joined us at this lecture. Mr. Tan is the executor and trustee of Mrs. Ong's estate. Prior to his retirement, he spent most of his career working for a precision engineering company, and as he was just explaining to me, he's working on a book of his own at the moment, not about Mr. Koh and Mr. and Mrs. Ong Tiong Tat as such, but rather about encouraging a spirit of philanthropy among our community. And the book is scheduled to be completed, I think, later this year. at which point we might have another book launch, which I'll be pleased to attend if invited. But now on to the main event. To introduce Sorna, I couldn't think of anyone better than our mutual colleague, Professor Tony Anghie. Tony is one of the leading scholars in the world in the school known as Third World Approaches to International Law, or TWAIL. His commitment to that project is evident in his research, which includes the leading book on imperialism and its relationship to international law, but it's also evident in his commitment to supporting future generations of scholars, including through his work to build up teaching and researching international law in the region. Among other distinctions, he has delivered the esteemed Grotius Lecture at the American Society of International Law and is currently the Secretary General of the Asian Society of International Law, and it's my pleasure to invite him to the podium to introduce our distinguished speaker, Professor Sornarajah. Tony, the floor is yours.
Thanks very much, Simon, for that generous introduction. Distinguished guests, ladies and gentlemen. I feel very honored to be in this position to introduce Professor Sornarajah, henceforth known as Sorna, because really he requires very little introduction. But let me nevertheless try and perform the duty allocated to me and say a few words about him. I associate many qualities with Sorna, but one of the qualities which is most endearing about him is his contrariness. Sorna is a very stubborn person, and he's a very innovative person. And I can't help telling the story told to me by my uncle, who was at school with Sorna almost 50 years ago, 60 years ago. And Sorna and my uncle went to the same school, and my uncle was telling me about an occasion when the teacher got exasperated because of something that Sorna said and his disobedience. I'm sure it was principled disobedience. And the teacher said, Sornarajah, get out of the class, stand outside the class. And, well, people then wandering down that corridor found Sorna standing outside the class, but standing on his head. And so this is a sign of the type of innovation, you could say, and contrariness that we might associate with Sorna in different ways. And I associate this occasion also with a certain, you could say, contrariness, because we are celebrating all Sorna's achievements here. But I have to say, they are far from over. So he is not the sort of person to actually recede gracefully into retirement on the occasion of having an extraordinarily distinguished career in his many different fields, public international law and international investment law. The really interesting thing about Sorna, and this is something that Simon alluded to, is that it is now that the rest of the world is catching up to what Sorna said 30 years ago about the whole complex regime that we call international investment arbitration or foreign investment law. I have here the book that we are celebrating in many respects. Sorna's first edition came out in the early 1990s. It was really the first textbook on this subject, which has now become so dominant a field in international law. And the book looks new, but I read it very carefully. And in fact, I used to teach from it when I taught foreign investment law. So this is actually Sorna's moment when the rest of the world is catching up, and all the criticisms he made of this regime, criticisms which are based on brilliant scholarship and insight. And that is what impresses me most, that he saw the implications of this regime far before other people did. And it is only now that the European Union and UNCTAD and various other institutions are actually acknowledging and accepting and almost presenting as normal the insights that Sorna articulated many years ago. And he suffered for them in many respects because he was denounced as being a radical, as being extreme, an extremist, and as somebody who didn't really understand how the regime worked. And it is a very interesting process in terms of the sociology of scholarship to actually appreciate why it was that he was diminished in all these ways and how orthodoxies in the field are established. I do wish, now that Sorna is proving right in so many respects, that greater acknowledgement is given to the fundamental insights that he provided. Because the other thing I find very annoying, I have to say personally, is that many of the scholars who actually now critique the regime in the way that Sorna did don't really acknowledge that Sorna said so many of these things earlier. I won't go on further about the scholarship because Simon just informed me that I have to comment on Sorna's lecture, so I'll save the comments for later. The other contrary aspect about Sorna is that he likes to believe that he is sort of majestically alone, splendidly alone, that he is not understood, that he lives in kind of defiant, heroic isolation. He refuses to associate with third world approaches to international law, saying, no, I'm supportive, but I'm not of you. And yet, I would say, think of this situation. We had to change our venue today because so many people wanted to come to this event. So Sorna, that's not the sort of isolation, really, that I think the expression is res ipsa loquitur, if I can get my Latin correct. The present so many people here who have so much respect, admiration, and affection for you speaks for all you have done for the school and for your students. Let me just say a few things about Sorna's contributions to the law school. Sorna, as we know, is very modest. It was only when I spoke to colleagues almost haphazardly on various occasions that it emerged that Sorna had played a fundamental role in their careers. He had mentored them, he had encouraged them to take up subjects that they found challenging, he had co-taught with them. I just spoke to Jiang Yu on the way here, and he was telling me about how the wonderful thing about Sorna is Jiang Yu and Sorna disagree completely, and yet they are wonderful colleagues, and that is what makes their co-teaching such an important event for the students. Again, Sorna's contrariness. You can always rely on him to disagree. And so he's had this lasting, you could say, impact on the careers of so many of us. One of the interesting things is I still regard him as a mentor. I'm almost 60, but there's no age limit to mentoring, actually. You could still regard people as mentors, however far developed you are in your career. But he's played that role to so many people. In fact, another colleague said about this, she said, we think of Sorna as the Yoda of the law school. I didn't know how to take this because I'm not a Star Wars person. I'm more a kind of Game of Thrones person. But I looked up Yoda in Wikipedia. It's not good scholarly practice, but I do confess I checked Wikipedia. And it turns out being Yoda is a good thing because it means, he was the Jedi master who trained all these, wonderful people. So Sorna has had a remarkable impact on the law school. We're all grateful to him in that respect. And I think just the final thing I want to say by way of an introduction is I think NUS is extraordinarily fortunate that a scholar of absolute world-class status and quality has been here at NUS for all these years. But I also think it is a huge compliment to NUS and that Sorna has been here for all these years, continuing his struggle for international justice, more of which he will talk about now. So thank you. We look forward to Sorna's lecture on the topic precisely of the past and future of international law and foreign investment.
Thank you very much, Tony. I would have to live a few more years to catch up with all those kind things that you have said of me. Today, I'm going to talk about the past and the future of international investment law. It is really about my past and about what I think the future of this subject is going to be. My past is a long one, as Tony said. He's 60, and I'm very much older than him. So I've had a very long past in this subject, and my association with it started pretty early. I was a teenager when I got interested in this subject, because at that time in my country, Sri Lanka, Ceylon as it then used to be called, the political dispute that was ongoing was the nationalization of the tea estates of Sri Lanka. All of you drink Ceylon tea. It still continues to be called Ceylon tea, not Sri Lankan tea. And of course, Ceylon tea was controlled by the large tea companies, Lipton's, Brook Bonds, and other companies. The farmers in the area had been driven off, and the British had converted their farms into tea estates and had very lucrative income from these different tea estates. But the independent governments of Ceylon then had embarked upon this course of nationalizing the tea estates. And the then current Western international law demanded that they should pay full compensation for the taking over of these estates. Ceylon at that time was not able to fulfill this requirement because the coffers were not that great. They were rather empty. So came about the argument that if a colonial state is subject to nationalization, or the foreign investors of a colonial state are subject to nationalization, it is not necessary to pay them full compensation. The argument, of course, was repeated by almost every Asian country that became free. When the Malaysians nationalized the rubber estates, the Indians nationalized their tea estates, when the Indonesians nationalized their oil, the same argument was put forward that it was not necessary to pay full compensation for companies that had exploited the natural resources or the other resources of a colonial state. So there came about a schism between the developing countries which had become independent and the former colonial countries of Europe, and of course the United States, which was then a dominant state. The companies selling petroleum in Sri Lanka were American companies. So the United States was also implicated in this dispute that had arisen. So from the teenage years as a law student, and later as a young lecturer at the University of Ceylon, I came to be attracted to this subject and the rhetoric that surrounded this subject. You can well imagine that the leaders of Africa and Asia were very charismatic people. In Asia, there was Nehru of India, Lee Kuan Yew of Singapore, Tunku Abdul Rahman of Malaysia, Sukarno of Indonesia. In Africa, there was Kaunda of Zambia, Kenyatta, and Mandela, who was then in prison. So these leaders then contributed to this rhetoric that surrounded the Third World claim that there should be a new just international economic order, which came to be known as the New International Economic Order. So much of my attraction to this subject was associated with the political trends that were taking place in Africa and Asia. After my initial years as a young teacher at the University of Ceylon, I went to do postgraduate studies in England. In England, my views were not looked upon with any happiness. I was told that whatever I wrote had a lot of rhetoric, but no law. So I had to live with that criticism that I was full of rhetoric, very much like the men I admired, the third world leaders I admired, and that my law was not sound. I did learn some law from the law schools that I was attending in England, but I found that it wasn't too exciting because the law that I learned was very similar to the law that was taught at the University of Ceylon and at the other law schools of the Commonwealth. there was a lot of black letter law, and I continued to learn black letter law at the universities in England. It was when I went to Yale that things changed. At Yale, there was a bit of a different attitude, not a bit of a different attitude, but a remarkably different attitude towards the study of law, in the sense that it was taught in context, in the political context of the international community. But more than that, the idea was that you should look at the expectations of the international community as expressed by the participants in the activities of the international community and shape international law in order to ensure that the objectives so articulated are realized. So this is a sort of an instrumental approach to international law, in the sense that you take the law, use it as an instrument for the achievement of certain objectives. Now, what was stated to be world community expectations in a grandiose manner by the Yale New Haven scholars was nothing but the expectations of the United States. So here was a sort of a school that formulated a thesis that ensured that international law was geared towards the achievements of the objectives of the United States. Now, the difference that I made was that I thought that this was a grand school, but that the community expectations must reflect the interests of the vast majority of the people of the world, namely the Latin Americans, the Asians, and the Africans. After all, they are the majority of the international community, and it is their expectations that must be realized. International investment law is a very American subject. It was in the context of the American relations between the United States and Latin America that it was initially developed. And of course, the United States had advanced its understanding of the law as customary international law, when in fact this customary international law was exclusively made by the United States. So the change that I made as far as the New Haven School was concerned was to ensure that the expectations of the third world people are realized through the use of international law. When I taught in Australia, this idea became entrenched, because there I was able to see that the Australian government mistreated the Aborigines, used their lands in order to profit from mining. The Great Australian, the Broken Hill Proprietary Limited, the mining company, used its vast capacity to exploit the copper resources of Papua New Guinea. So I was confirmed in my belief, and every academic, of course, is a product of his own experience. And my experience confirmed me in the belief that there should be an alternative international law that must be argued. So when I came to the University of Singapore, the National University of Singapore, I had already formed this viewpoint that there must be a different attitude or approach to the study of international law. So it's in that context that when I had my first sabbatical year that I wrote this book, The International Law on Foreign Investment. The ideas in that book are commonplace now, but the arguments simply are that you cannot regard the American viewpoint or the European viewpoint as as customary international law, simply because of the fact that there were at least two other contenders for acceptance as international law. The Soviet Union and its allies, principally China, did not recognize the concept of property, and obviously would not have accepted the idea that foreign investors' property must be protected. And then, of course, there was the developing countries of Africa, Asia, and Latin America taking the view that there was, in fact, very little international law on the subject of foreign investment, that disputes that arise must be settled in accordance with their own laws and by the tribunals of their own countries. So there was a three-way split at that time that one could determine. And it would be an error to say that there was just one customary international law and that customary international law was made by the European states and by the United States. At this stage also, there was a very powerful movement that had emerged. There were Asian and African writers like Mohammed Bejawi of Algeria, Abisab of Egypt, Ramprakash Anand of India, articulating the idea that international laws, Eurocentric moorings must be ended, and that there must be an alternative international law articulated on the basis of justice-related norms. So this was a sort of a project in existence, and I thought that in writing this book, I was merely contributing or advancing a project that was already begun by the great lawyers of Africa and Asia. The project to shift international law from its Eurocentric moorings and ensure that it becomes a law that is geared to the ends of meeting justice, the eradication of poverty in the developing countries, and ensuring that they are protected from the use of force by the major countries of the world. So it was a sort of a articulation of the idea that a power-based international law should cease to be, and that international law that is based upon notions of justice should come about. So there was this book that I wrote in 1992, principally articulating these ideas that there were different ways in looking at this subject of international investment law, as the West called it. I prefer to call it international law on foreign investment, trying to locate that subject within the broader subject of international law. So that came about then an articulation of the view in this book that one must recognize the existence of alternative systems of international law on foreign investment. At that time, of course, there were treaties coming into vogue, the investment treaties, some of which provided for dispute settlement. I explained the existence of this treaty practice, which has started in 1959, the first such treaty being the treaty between Germany and Pakistan, on the basis that they provided for the fact that international law was uncertain. After all, why have bilateral treaties if the law was certain? If there was, in fact, a customary international law as stated by the United States, what is the reason for bilateral investment treaties? So my argument was that investment treaties come about only because of the fact that there was a dispute as to what the international law on the subject was. So then, of course, it's pretty logical to explain the fact that two states come together and state the law that would apply as between them without altering, of course, the law that they would articulate collectively at the global level. So the third world countries then made these treaties, no doubt, but were conscious of the fact that they argued for a new international economic order at the global level. So that's the reason I gave for the existence of investment treaties in 1992. 1992 was also a significant year for another reason. It was the year in which a case called WAPL was decided. It was a case which concerned Sri Lanka, my country. It was the facts had some resonance with me because I come from a Tamil area of Sri Lanka, namely the north and the eastern provinces of Sri Lanka. The Tamil Tigers were fighting for a separate state for the Tamil people, arguing that they were persecuted and that as a minority people, they should have a right to secession, to secede from the rest of Sri Lanka and form their own state. So this had become a civil war. And during an engagement with the Tigers, the Sri Lankan army had been attacked by the Tigers, who fled for refuge into a prawn farm that belonged to a British investor. He was a Hong Kong person, but he was regarded as a British investor because the Hong Kong people were entitled to the protection of British treaties at that time. So here was a situation then where the Sri Lankan army carpet-bombed this prawn farm in which the Tamil Tigers were hiding. They killed a lot of people. They killed a lot of innocent employees of this prawn farm. They may have killed a few tigers who, of course, knew how to escape. So the numbers of tigers killed, it would appear, was very low. But the prawn farm was destroyed, and the question was whether this foreign investor could have a remedy. So in 1992, for the first time, this tribunal, in a very short passage, not argued properly, not with no authority stated, indicated that the dispute settlement provision in the investment treaty could unilaterally be invoked by an investor before an arbitral tribunal that's mentioned in the treaty, namely the International Center for the Settlement of Investment Disputes. So from then on, there was exponential growth of investment arbitration. Previously, ICSID, the International Center, was a very dormant center. It didn't have much business, maybe 30 cases or so, if it had been lucky to count. But after WPO versus Sri Lanka, the cases multiplied, as did the investment treaties. Many more investment treaties came into being, and many more investment awards came to be made. And a recent UNCTAD calculation in the UNCTAD hub on the web says that there are 942 cases on investment arbitration. So this is big business now. And of course, a lot of law firms and lawyers are involved in this dramatic growth of investment arbitration. Everyone wants to study it. Everyone wants to join large firms. Everyone wants to exploit the poor people of the developing countries. But, I'm sorry, I laugh at my own jokes. My students know that, okay? I laugh before I make them, which is a sign that you should laugh too, right? Okay, so here was the situation then that had come about. The exponential growth of these cases before investment tribunals. The other facet that happened in 1992 or just around then was the great spurt of globalization. The Soviet Union had fallen, and of course, the only big power that was standing, the sole hegemonic power of that time, was the United States. And the United States then wanted to drive the law that it pleased. So we find then the United States making the World Trade Organization, ensuring that trade was liberalized, that flows of assets were protected. It embarked upon treaty practice, and that came about what was known as the Washington Consensus, with the World Bank, the IMF, and the White House jointly driving this idea that neoliberalism must be the triumphant philosophy within the international community. So there was a sort of there were three important factors coming together around the 1990s. It was, as one writer put it, the roaring 90s, in the sense that here was a hegemonic power that was ensuring that the world was shaped in its own image. And we find that the number of investment treaties also shot up during this time, from about 300 treaties in 1990. By the time the 90s end, the 1990s end, there are 3,000 treaties, all of them indicating that there would be dispute settlement at the unilateral instance of a foreign investor. Because the developing countries were either pressured into signing these treaties or they voluntarily signed them thinking that this new mantra that had come about, that you must liberalize if you are to develop, was to be accepted as the truth. So it's in that context that, we see the law developing. And we find that arbitrators who decided these cases also were caught up in ensuring that there was a restatement of the law in the treaties through interpretation. So we find the building up of investment law through many awards given by arbitrators. The most fascinating of the interpretations that were given was to revive a dormant principle in investment treaties known as the fair and equitable treatment. All of us as lawyers know that you cannot interpret this particular clause. What is fairness? What is equity? That's anyone's guess. But for the first time then, with the Argentine cases coming up, we find a definition being given that the fair and equitable treatment involves the protection of the legitimate expectations of a foreign investor. The facts of the Argentine economic crisis and the cases that followed that crisis are accommodative of the interpretation that was given. Argentina had made a large number of investment treaties after 1992. Previously, of course, it was the home of the Calvo Doctrine. It did not make any treaties at all. Come 1992, caught up in this web of neoliberalism, it made several treaties with the United States and other European countries. So we have these treaties, and also Argentina, in order to invite more investments, promised that there would be a parity between the peso and the dollar for all time, and that the price of utilities in Argentina would be geared to the index on utilities in the United States. So these two promises were made, and then came the economic crisis of 2000. Argentina had to relinquish these promises and devalue its currency. The devaluation resulted in some 60-odd different cases. And in most of these cases was articulated this idea that if a foreign investor was given a legitimate expectation as a result of promises, like the promise that the parity between the peso and the dollar would be kept, the failure to maintain this promise would result in a violation of the fair and equitable treatment. So comes about a rule by interpretation of this very simple clause, fair and equitable standard. There is built a sort of a case law on the ground that legitimate expectations, once created in the investor, must be honored, and that if there is a failure to honor them, damages must ensue. Of course, there's no attempt made as to how one would draw this notion of legitimate expectations. We know this phrase is used in English administrative law and in, of course, administrative law of our systems, the Commonwealth systems. But we use it only as a rule of procedure, not as a substantive law. It is very rarely, if at all, and I think I did check this with Swati before making this statement, and she also agrees with me that it is never or seldom used as a substantive rule. Rather, it is used as a rule of procedure. So there's no way in which one could say that this principle is found in the domestic legal systems of the world. Neither can it be said that it is easy for the drawing of the inference that fairness and equity require that legitimate expectations be honored. So we have this very fabulous rule, which today is the basis of international investment law. It used to be expropriation, but expropriations are the type that give rise to damages hardly occur in modern times. No state is crude enough to go and seize the investor's property. So what happens would be indirect expropriations, which rarely, if at all, carry compensation. So the main thrust of the law is based upon this idea of legitimate expectations, which of course is not legitimate at all. The interpretation cannot be supported in any logical way, apart from the fact that it arises from a figment of solitary arbitrators, and that as a result of its repetition, it has passed into modern law. The UNCTAD website also points out that in the cases that were decided last year, legitimate expectations was the doctrine that was featured the most, that it has now become the mainstay of international investment arbitration. As a result of this then, and of course as a result of a lot of other exorbitant interpretations that have been placed on investment treaties, there has been a crisis that has developed. States, naturally, are rather cheesed off with what has happened, and they have responded in different ways. South Africa, for example, has terminated all its treaties and announced that its law, its domestic law, and its domestic tribunals must be the sole arbiters of investment disputes. There have been terminations of investment arbitration, some of the Latin American countries like Bolivia, Venezuela, Ecuador. There has been termination of treaties by India and Indonesia. The European Union as a whole has announced that it will not use investment arbitration in its treaties anymore, but that in future, disputes will be decided by an investment court, which it shall set up. So there is a sort of a response to the illegitimate interpretations that have been made by arbitrators. Another interpretation, of course, and here I look at the future course. I try in evening light, so to speak, look at what would happen in the future to this. Now that a legitimacy crisis has arisen, we see that there is, of course, withdrawal from the treaty system. There are ideas relating to the setting up of an investment court. Then, of course, there are, as perhaps softer responses, the emergence of what some people refer to as balanced treaties. The balanced treaty is different in this sense that whereas the earlier treaties, that is the treaties from 1959, when the treaty practice started, to about 2004, they emphasized the protection of foreign investment. And this was their only goal. There was nothing else that was mentioned in the treaties as an objective besides the protection of foreign investment. The balanced treaties are different in the sense that they think in terms of the possibility of the existence of circumstances which either exclude or provide a defense to liability. And that's now becoming commonplace. You see that used in treaties that Singapore makes with the EU, with Sri Lanka. There are defenses to liability that are provided. So if you look at the Singapore treaty practice too, you would see that whereas the earlier treaties emphasized only the protection of investment, the new treaties do think in terms of the existence of possible defenses. The Indian treaty goes to the extreme in the sense that the Indian model treaty goes to the extreme in the sense that it tries to bring about a new type of treaty which contains a wide variety of defenses. That would include measures taken to protect the environment, measures taken to protect human rights, measures to ensure that corporate responsibility is maintained. Then, of course, it talks in terms of the right of a state to regulate foreign investment. So the structure of the Indian treaty is going to be different. And this probably may trigger off other treaties that use the Indian model and ensure that in addition to the protection of investments, there would be a wide range of measures that would provide an exclusion of liability or defenses to liability. So that is something that one could see as a change that would come about as a result of the crisis that has been provoked in investment arbitration. The most important thing to my mind is the rise of China and the attitude that China would take to investment law in the future. As you know, of course, China has announced the One Road, One Belt policy, or the Belt Road Initiative, as the Chinese officially call it. And of course, this is going to mean that China will very soon become the most dominant capital exporter of the world. The United States used to be that, but now it is the largest capital importer of the world, as is the European Union. So what is happening is that there is a great change that is taking place, with China being a capital exporter, India perhaps, and you can see this happening. China owns the Volvo company in Sweden. The Indians own Jaguar. So the picture of the world is changing as far as investment is concerned. And much of the investment that would go from Asia. Singapore has an external economy, exports capital. Malaysia does as well. But to a large extent, it will be the Chinese who would be doing this. In the Belt Road countries, the Chinese would not have a heavy investment treaty. They would rather use diplomacy or other means to settle disputes that arise. So we see that happening in Sri Lanka, for example, where there is dominance of Chinese capital. You have the Chinese building roads. They're building a whole city known as the International Port City in Colombo by dumping sand into the seas that are adjacent to Colombo to create a new international financial center. So there's a lot of Chinese activity that is taking place in our region. And I suspect that in this activity, the Chinese would have a very benign attitude towards investments that they make, as is evident in the case of Malaysia, for example. There was no idea to sort of resist the move of the Malaysian government to renegotiate the existing arrangements. I think that would be the attitude that China would take in respect of the investments that flow into the African and Asian states that border the belt and the road. As far as the rest of the world is concerned, the Chinese would use, I believe, the traditional investment treaty and would be prepared to play the game in accordance with what the West does. And the Chinese would be very capable of doing that, in the sense that they would be pretty equipped and prepared to ensure that they give as good battle to the Western lawyers as the West would give them. So we can see that cases are being brought against China, and that Chinese investors are bringing cases against Belgium, against other European countries. Now that would increase, and that increase in the number of Chinese investments in the West, in the United States, would result in a change to international investment law. We see that the defense of national security is becoming more prominent. We see that in the case of Huawei, where national security comes into play. And of course, the defense of national, or rather the exclusion of national security is used in the American treaties and would be used increasingly in the Chinese treaties. So what would then happen is that we would see a greater use of the preclusion of national security by the Western states, either to keep Chinese investments out, as they do in the case of UNCTAD, or after the investment comes in, to terminate such investments which are seen to be hostile to the interests of the United States. So this is going to be a change. And the impact that China would bring about on this area of the law is something that one has to watch carefully. The law would, in my estimation, change in a benign way as far as Africa and Asia is concerned, because there is the Chinese aspiration that they provide leadership to the Afro-Asian world. And then, of course, the hostile law that is involved in investment arbitration probably would continue as far as investments in the West are concerned, because of the fact that they believe that these treaties are more capable of protecting investments. I also see that there would be a greater interest in fashioning laws that bring about responsibility of multinational corporations. So far, despite the fact that the multinational corporation is the most significant actor in international relations, no one has sought to recognize the personality of multinational corporations. No one has sought to say that a multinational corporation can be responsible for the misconduct or the mishaps it causes around the world. Bhopal happens, nothing, no consequences take place. There's the Rana Plaza disaster in Bangladesh, no consequences, no liability is imposed. So there is a problem here. And of course, the next move would be to ensure that responsibility is brought about in the multinational corporation in order to see that damages are paid to the people affected. After all, it's the multinational corporation which colonized us, the British East India Company or the Dutch East India Company. They were significant actors in international relations. And till now, many hundred years later, there is no move on the part of Western international law to ensure that this major miscreant in international politics is not subjected to any liability at all. So it is a facet of international law that has to be changed. And of course, one can see that that change is coming with Ecuador initiating a move along with other countries to ensure that a code of conduct is brought about that would penalize the activities of multinational corporations. So the idea of corporate responsibility in the Indian Treaty also conduces to this notion that multinational corporations must share a modicum of blame for what they do in the course of their activities. It is also interesting to see that the Indian Treaty says that a multinational corporation, in order to obtain the protection of the treaty, must continue to respect and abide by Indian laws. In other words, here is another sanction that would come about, that if a multinational corporation were to break the law of the host country, it would move out of the protection of the treaty. That idea, of course, has been stated in an Indonesian award, and it could well be that it would also become a norm. Now, as far as those who are in the business already, the large law firms and the arbitrators who have made so much of money, I say that the treaties came about largely because we were told in the third world that economic development is a necessity, and the only way that economic development would take place is when you make treaties, and the treaties would generate the income, the inflow of more investments because of the security that the treaties create. We have not, the treaties have been there for about 70 years now. we have not seen economic development taking place as a result of these treaties. Economic studies now show that there is very little correlation between investment treaties and the inflow of investments. If at all economic development has taken place, it is the economic development of the large law firms and the arbitrators who are in this particular area. Their economic development has been assured, but I do not see economic development in the third world countries that have made these treaties. In fact, Philippines reported after the Fraport case that it spent $50 million to defend that case, which they won, no doubt. But the lawyers' fees there amounted to $50 million. And Pakistan, the Attorney General of Pakistan made a statement saying that the damages that were claimed in 3 investment cases against Pakistan amounted to the year's GDP of that country. So the question is, where is this promise of economic development? Economic development has not taken place. In Argentina, there were 60 cases brought at a time when Argentina was flat on its belly, suffering an economic crisis. So this is a massive hoax that has been made up, a hoax that is very reminiscent of the Piltdown Man. I wonder whether you know about the Piltdown Man. This was a case of a scientist taking the bones of a chimpanzee and doctoring it in such a way that it would resemble a fossil. So he buried it, dug it up, and said that this fossil was 500,000 years old, and this skeleton is the skeleton of the oldest known man found in this English city of Piltdown. And it took 40 years for scientists to unravel this hoax. Investment arbitration under investment treaties is very much a hoax, I tell you. And it has taken just about 20-odd years to unravel this. But it's going to be around for a long time because the treaties have been worded in such a way that there are sunset clauses and other clauses. The so-called balanced treaties have not been considered by investment arbitrators as yet. All the 942 cases that are mentioned in the UNCTAD website deal with the old type of treaties, not the new type of treaties. So there's much to be done in this area. And as academics, we must be conscious of the contributions that we have made in the wrong way. We have supported the existence of a hoax for a long period of time simply because of the fact that there is a pot of gold at the end. There's a hope that you could become an arbitrator too and earn a lot of money. So this drives us to write the wrong stuff, I think, with great respect. I say that we write the wrong stuff lured by gold. So this has to stop. The international law of today has many important things it is worried about. There's climate change, there's environmental pollution, there's the desecration of human rights. And of course, then if that is so, then you should not fragment international law and see that there is so much of emphasis on the protection of a multinational corporation, which is a desecrator often of human rights, of the causer of environmental pollution, and a contributor to climate change. So I think that this academic role also has to be changed. So I think I should stop here. I know that as evening light approaches, I must say that I shall, as Tony said, with increasing vigor, seek to do what I have been used to doing, because it gives me great pleasure to know that this has not, though it started as a lonely life, it has not been a lonely life. I know that I have support of a lot of young people all across the world, from Holland to Canada to the United States to Australia, from India to Sri Lanka. So I am not alone in this, and I'm conscious of that, though Tony says that I am a lonely person. I'm not really. I like you all, and I see many of my students here. But the most pleasant journey I have made in the last 32 years is with my colleagues at the law school. And we saw a rather ordinary law school, and we have made it in our journey into one of the best in the world. Thank you very much.
Thank you, Professor, for that very interesting lecture and for your kind words about NUS law. We now invite Professor Angie to join Professor Sorna to comment on the lecture and to take questions. Members of the audience, if you have any questions, please feel free to use the standing mics placed along the aisles. Please introduce yourself and keep your comments and questions brief. Thank you.
Well, Sorna, it really is so. So let me simply say that our colleague and Sorna's student, Jean Ho, said that actually all Sorna's admirers, and many of his critics too, actually, perhaps, were looking forward to this lecture. And we are just so fortunate to hear such a visionary, comprehensive, historical, autobiographical, legal, and wonderfully insightful overview of this very complex topic. I feel I really shouldn't say very much, but one thing I felt was to try and frame Sorna's talk in terms of a passage from one of his articles. He says, "The life of a third world international lawyer is devoted to resistance of norms of international law designed by agents with power to promote the interests of those who are powerful in the international community." And we can see in his talk, in his account of his lifetime's devotion to this cause, how one could actually pursue a career as a third world international lawyer. He's a wonderful model in that regard. I must say, Sorna, I'm sort of curious. You could have been so much richer if you had simply done the right things, because think of his qualifications, think of his background, think of his color. Because what international arbitration lacks at the moment is really a significant contribution made by people of color, if you can use that term, saying the right things. And Sorna would have been really played a wonderful role in that regard. And this really just reminds me of another feature of Sorna, and that is his integrity, both in his scholarship and also very much in his personal relations as well. Just some of the highlights of his talk. I mean, one thing that seems really striking is that international law seems to have been devoted to enhancing corporate rights much more effectively than enhancing human rights. So it seems really interesting that corporations have far more rights and far more protection under international law than human rights does. So that seems to be somewhat anomalous in terms of this whole goal of achieving international justice. Perhaps another thing that struck me was the irony of a situation where once the tools created by the West or Western arbitrators were then becoming deployed by China and India, once that happened, then suddenly the West said, oh, this whole thing is very problematic. So it is not just Ecuador. Sorna mentioned some of the countries that are very concerned about these things. It is the European Union, which is having a whole review of these things. And it's hard for us not to see this development taking place because of the fact that now Europe is at the receiving end of precisely the technologies that it had used against the non-European world for centuries earlier. I have another whole, I suppose, view about, we should remember that Singapore, it was the East India Company that really founded Singapore in many ways. So companies have played a long role in this history, and perhaps they continue to do so. It is heartening to see that there is this movement towards corporate responsibility, and there are attempts to create a treaty that would hold corporations responsible for any violations of international law. Again, it seems very anomalous that historically, corporations have been extraordinarily successful in acquiring rights under international law, but not responsibilities. And so the same could be said of human beings. So human beings have the protection of human rights, but they can also be held responsible under international criminal law for the atrocities they commit. So in terms of the human being, there are rights and responsibilities. But in the case of the corporation, it's been proven to be extremely difficult, as Sorna said, to actually establish that corporations have legal personality in international law that could result in them being held responsible under international law for violations of human rights and so forth. So these are simply some of the highlights of the many rich things that Sorna said that occurred to me. Sorna, do you want to answer the question of why you chose not to become even richer?
Well, I must say that I held the C J Koh chair for a very long time, and the trustee of the C J Koh Fund is here, and I was not involved as a result of holding this chair. And I must thank the C J Koh Fund and the trustee for enabling me to hold this chair for so long, despite the little work that I did, I must say, yeah. And
4 books in the last
no, that's right. But yeah, and I'm sure that the next holder would enhance his reputation even more. And thank you very much for the funds that you made available. Thank you.
Thanks very much for that comment, Sorna, because Simon, I hope you note the gravity of Sorna's comment, because what he says is, if you pay your academics really well, then they will actually produce scholarship of integrity without being lured by the corruption of providing theories for all sorts of really very untoward activities. But enough of us, please. So many of you have been students of Sorna's, and we have in the audience extremely eminent international lawyers from the Attorney General's Department, from private practice, scholars, all here in the audience. So please, as Jaya said, if you have any questions, please feel free to go to either of the microphones. And please, I would only request that you identify yourself and that you ask your questions succinctly. Gentlemen? Umakant. Yeah.
Thank you, Professor Sornarajah. Although I have nothing to do with international law, but one of the questions, as you were speaking, it seemed like a lot of the issues have also arisen because these treaties are more bilateral in nature. I was wondering whether you had any thoughts about, in terms of the future, whether a multilateral approach would make a difference to some of these, because some of the other scholars have argued in the context of public interest and issues like that, that a multilateral solution may be more acceptable or amenable to address. So I was wondering whether you had any thoughts about that.
Well, multilateral treaties have been attempted for a very long time. I mean, before the 1959 treaty, there was the Abs-Shawcross Convention, which was really something that was sponsored by the OECD. It didn't succeed, largely because of resistance from the developing world. Then there was a World Bank effort in the 1990s, and later a fresh attempt was made in 1995. But those who objected to that were the developed countries. Like, say, for example, the French thought that there would be diminishing of their culture if the United States was able to have access to the French markets. So this is entirely a developed country effort. The OECD is restricted in membership, but they were not able to bring about a multilateral treaty amongst the rich nations of the world. So I think it's a bit unthinkable that there would be a treaty that is brought about globally that would involve the developing countries as well. When it comes to bilateral treaties, I mean, there is a problem that these treaties are asymmetrical. They're one-sided. I mean, they say a treaty like the treaty between the United States and Bangladesh, it says that there would be a reciprocal flow of investments which are protected. That's a naked lie. I mean, what is the reciprocal flow of investments that take place between the United States and Bangladesh? So this system, as I keep saying, is a bit of a hoax. It's based on a series of lies that developing countries were told. Yeah, and if you have a multilateral treatment, a multilateral treaty, it would mean that multiplication of lies would have to be accepted at a global level. Yeah, thank you.
Thanks very much, Sorna. One more question, I believe.
Thank you. Thanks. My name is Andrew Chan, Alan Gladhill, one of your previous students, my corrector referee for getting me into Alan Gladhill. Thank you very much. No, so my question is this. I mean, one of the points which you raised was essentially the point about, if you like, requiring the multinationals to take responsibility. I wonder whether there is a possibility, because what actually happens in many of these particular claims, you have the investor bringing a claim against, I suppose, the entity or the country itself. Query is, if you make a claim, presumably, is there an argument and therefore there's a submission to the jurisdiction of, I suppose, a tribunal? Is there a possibility that the state can also bring a counterclaim? Is there some argument because of your submission or what have you, that investors should also be subject to, I suppose, claims in relation to the very claim for which they are seeking recovery? And if so, indirectly, is there a possibility of, at least in respect of those who bring claims, if you like, imposing on them some responsibility or some recovery?
Yes, I mean, counterclaims, I think it's going to come into vogue in the sense that many tribunals have considered counterclaims. But the idea of directly suing a multinational corporation, that is an unknown thing as yet. I mean, so Ecuador would probably initiate a course that would enable the development of the law towards the recognition of a right of a state to sue multinational corporations. This is not to say that all multinational corporations are bad. It's just to say that some of them do engage in rather suspicious and atrocious practices. Yeah.
Thanks, Sorna. Sorna has... right, the time. So Sorna refers to the time, and perhaps one more question. Yes, sorry, one more question, please. Yeah.
Thank you. My name is Mogi. I'm an MPA candidate at the Lee Kuan Yew School, and I'm from Mongolia. And in my previous life, I was a stockbroker, so I had to do a lot with foreign investment. In Mongolia's case, there's one major mining company. I won't say the name, but that is 9 times larger than the GDP of Mongolia. And we have an investment treaty on a particular mining deposit, which was signed in 2008. But there has been always disputes that Mongolian politicians, where populists would say that Rio Tinto took advantage of us. Now we need to change that investment treaty. And of course, Rio Tinto would oppose that. But the argument would be that when you are negotiating a deal with a larger player, with a multinational, there's a significant disadvantage where the expertise is lacking in a developing country. But the argument for the large multinational would be that, of course, it's a business company, it's a business, they have to take advantage of every opportunity. There's nothing maybe illegal about that. But in the future, they will have multiple troubles. So what do you think that in these situations countries should do, or even the multinationals should do, to prevent the future attempts to renegotiate treaties? Perhaps the multinational should pay for the experts, the legal advice, the financial advisors for that particular countries to prevent future troubles for both sides.
Yeah, in Mongolia, the problem was that many of these contracts that were signed had what were known as stabilization clauses. So some of the decided cases like Paushok, I know you're familiar with it, that was a large multinational corporation, probably the one that you mentioned. Again, this idea is that if you have a stabilization clause, then you're creating an expectation, right? So what is triggered off is this notion of a legitimate expectation that arises from the existence of a stabilization clause. It's pretty obvious that people who negotiated these treaties wanted the foreign investor to come in. So they were pretty lax about the initial negotiation. So can you change it later? That's going to be very difficult. The foreign investor has to agree. And then, of course, there is this investment treaty, which is backed by investment arbitrators who would decide in favor of the foreign investor. So that's the difficulty that your country would be caught up in. The answer that we try to give is that, like you said, there should be a right to renegotiate treaties that were made without too much of a understanding in situations where the bargaining power was non-existent. But these are ideas which have not gained much traction because of the dominance of the system of investment arbitration, which has still not been broken down, right? Yeah.
Thanks. I don't think there are any other questions. So given that, may I please ask all of you to join me to thank, and I should also recognize Mrs. Sornarajah, who is here, and who has been so important to Sorna's life and to whom this book is dedicated. And again, let me ask all of you to thank Sorna for this wonderful evening. We have all benefited from his wisdom.